Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we are going to have a chat about an application by some plaintiffs to bring a derivative action. And you might remember that we speak about derivative actions from time to time, and that essentially is an application brought by someone in relation to a company, almost always a shareholder, to sort of stand in the shoes of that company and bring a claim on behalf of that company that company wouldn't otherwise bring. Now, this is a bit of an interesting one today, and you and I are going to need to hold hands to make sure we both understand the facts that we're speaking about. Right, so the company we're speaking about today is a company that is actually the trustee of a self-managed superannuation fund here in Australia, and what the plaintiffs are trying to do is to say, hey, we want leave to stand in the shoes, to seek leave to bring a derivative suit on behalf of this trustee in order to seek some shares that we say were improperly bought back. All sounds a bit fiddly, so let's just work through the facts. Now, what our plaintiffs say is that in 2008, the former trustee of this superannuation fund bought some shares in a company. What the plaintiffs say is that the shares that the former trustee owned were then improperly bought back by this other company, saying this other company engaged in a buyback and it bought back those shares off the former trustee improperly. It was unlawful. Now, what happened after that was the former trustee stopped being a trustee, then our plaintiffs became trustees, and then the defendant in this application became the new trustee. I hope that's clear as mud. We'll quickly review it now. So we've got a trust, right? This self-managed superannuation fund. What the plaintiffs say is that there are some shares that ought to be in that fund, and that the company that issued those shares improperly bought them back. And so we are the plaintiffs, and we want the trust company to sue to try to fix that unlawful buyback. That's what they're trying to do. But the impression I hope you got working through some of those facts is that the plaintiffs themselves were directors and shareholders of the current trustee, and indeed they were also trustees of the trust for a time. And so there's this challenging situation the court is presented with, where the court is essentially having the shareholders and directors of a company to say, please, please, please give us leave to sort of bring proceedings in the name of the company. And so the court's dealing with this curious situation about, well, people who control the company in its entirety are nonetheless seeking leave to bring a derivative action on behalf of that company to go undo what they say is an improper share buyback. Now, the court then has to grapple with the relevant sections of the Corporations Act, and the relevant sections are 236 and 237. The criteria that the court need to work through are in section 237, and without saying any more numbers, let's just get into what they are. So the first thing that the plaintiffs had to satisfy the court about was the company going to bring the claim itself? Now, the court can't grant leave to allow someone to bring a derivative suit, to allow someone to stand in the shoes of the company, unless the court is satisfied that the company's not going to do it themselves. Well, in this case, the court is very satisfied and says, yeah, of course the company's not going to bring the suit. But the court observes that the reason the company's not going to do it is because the plaintiffs, remember, who are directors and shareholders of the company, aren't going to cause the company to do it. So it's the plaintiffs' fault that the defendant company isn't going to bring the suit. But in any case, the court is satisfied the company's not going to bring the suit. Where that point's going to become relevant is with the question of good faith, which is the second criterion that the court needs to look at. So the next question the court says is, well, is this application for leave to bring a derivative suit brought in good faith? And the court fairly quickly, with great respect and comfortably, concludes no, it's not brought in good faith. And the broad reasons for doing that are that the company finds, well, the plaintiffs, in their role as directors and shareholders of the company, could cause the company to do this anyway, and it appears what they may be trying to do is to cause the company to bring this claim without the assistance of a solicitor in order to avoid some form of responsibility. And there's a challenge that we're going to get to in a sec about the lack of evidence in this matter and the confusing, strange, sometimes fallacious reasoning that is engaged in by the plaintiffs. We'll get to it, I promise. So, Criterion 3, the third criterion, is it in the best interest of the company that the plaintiffs be granted leave to bring this derivative suit? The court fairly comfortably, with great respect, concludes no, and there are two broad reasons for that. One is the prospects of the claim are poor, and the other is the indemnity the plaintiffs offer is only $25,000. And while you and I might say that's a lot of money, in this case, it struck the court as not sufficient, and with great respect, it does not strike me necessarily as sufficient to indemnify the company in respect of any costs order. So criterion 1, is the company going to bring it? Tick, the plaintiffs prove the company's not going to bring it. 2, is there good faith? No, the company fails, so the plaintiffs fail that test. Test 3, is it in the best interest of the company that the application be brought? Thank you very much. Is it in the best interest of the company that the application be brought? Well, the plaintiffs fail that test as well because they're unable to say yes, and indeed the court finds no, it would not be in the best interest of the company. The next question the company has is I withdraw that. The next question the court has in the application brought by the plaintiffs is there a serious question to be tried in relation to these complaints that the plaintiffs make? Now, one of the challenges that the plaintiffs face is of their own making, with great respect, and that is that the evidence before the court is very, very... I'll withdraw the second very. It's lax. There's not as much evidence as you might expect to have in support of an application of this type. And so the court has only a bit of a narrow window into what's actually going on. Now, also relevant is that these facts have been the subject of 12 other pieces of litigation over the years, and in taking a look at those previous decisions, the court has said, it looks to us like there may be some other facts that are traversed in these other cases that aren't put before us in this case. So there are real serious questions about whether the plaintiffs have put enough evidence before the court to show that this buyback was indeed unlawful. But there is also a question of, well, is there some evidence being held back here on an improper basis? Well, the court says, notwithstanding these misgivings, and notwithstanding issues like action estoppel, what we sometimes think of as cause of action estoppel, issue estoppel, these sorts of things that are like, can you sue for the same thing twice? Notwithstanding these sorts of issues, the court says, well, it looks like there might be a serious question to be tried, and so the plaintiffs satisfy that test. So let's run through. There's a notice question that when we talk about derivative suits, we often gloss over, as I have in this discussion. Apologies. Remember what the plaintiffs were trying to do was to seek their derivative suit, and in order to do that, they have to tick those 5 boxes. Well, they failed the good faith box, and they failed to tick the best interest box. And so the court said was, notwithstanding some of these other issues, the application fails, and so the plaintiffs were not granted leave to bring the derivative suit on behalf of the company to pursue what they characterise as an unlawful buyback of shares. And I hope that discussion, that freezing weather, and this excellent bagel assisted you, and I look forward to speaking again soon over another coffee and in respect of another case note. Cheers.